Not all indictments come with a statement of facts, especially not in federal court, but I will say I think they did a pretty good job of just telling a story in here. And I always like to point that out, practice tips and everything, like get to the point, singular narrative, let's go. And they start out with one simple sentence. The defendant, Donald J. Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election. Boom, period. End of story. That's their case.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey, everybody. Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. As we speak, literally like today, this morning, the same day I'm recording this episode, our former president, Donald Trump, appeared in court in New York on a hearing on his state criminal trial. There, he's charged with, I think, 34 felony counts related to what we call the hush money payments to Stormy Daniels. And as we often do on the podcast, we look at high profile cases to see what we can glean from them. And girl, we couldn't get much higher, as Jim Morrison would like to say, in terms of the profile here. This is likely going to be the first criminal trial that goes of the four that Trump has. And so we will start with the presumption of innocence, of course, but really focus on the worst case scenario and, what if he's convicted, what are the possible sentencing implications? So helping us get set for sentencing today, I'm very overjoyed to introduce an esteemed colleague, also his first time on the podcast. We've worked together on cases and we share, more importantly, a mutual love of tequila. So we have much, much, much to bond with, but he's in a New York state of mind, being a fabulous, fabulous criminal defense lawyer from New York, handled these kinds of cases and then some in state court and federal court. Welcome, welcome, Counselor Richard Willstatter. How are you, sir?
I'm well. Thanks for having me.
Good to see you today. I wanted to first kind of let people know, who you are. I did a little bit, but I just want to give a little bit more of your bio. And you may not be surprised, but when I Googled the name Richard Willstatter, you are not the first Richard Willstatter that came up on the Googles. Do you know what I'm about to tell you? Or is this
Oh,
going to be a
yes.
surprise?
Oh,
Okay,
no.
so yeah, apparently your namesake is a Nobel Prize winner in organic chemistry back in the early 1900s or
1915.
1915. Well, you do know this. Yes, he won the Nobel Prize and then had some trouble with some Nazis in Germany and had to get out of Dodge, I guess. So I guess that's kind of an interesting story for another day. But this is not Nobel Prize winner Richard Willstatter. This is attorney. Are you guys related, by the way, or no?
Yeah, it's my grandfather's brother.
Are you serious?
Yeah, I'm serious.
Wow. Amazing. All right. Well, then I want to hear more about that. But this Richard Willstatter is as I said, great lawyer, graduate of Duke Law School, past president of the New York State Association of Criminal Defense Lawyers. The list goes on and on. He's been published multiple times in publications like NACDL's The Champion, on fingerprint evidence, habeas corpus, challenge to the Bureau of Prisons, which is one of my pet issues that I talk about on the podcast all the time. But, the list goes on, and I'm going to put his link in the bio. But I wanted to have Richard on here because, like I said, he plays in this sandbox locally, state law and federal law, and he's handled cases very much like this, and he has a real good handle on what's happening there on the ground. And we haven't really heard that much about what to expect when this case finally goes. And like I said, hearing today and the trial date, it looks like it was affirmed for April 15th. So we are, 3 weeks away from the start of this trial, if barring any unforeseen surprises. So that's what we want to start with. And again, welcome, welcome, welcome. Before we dig in, though, I do need to talk tequila with you for just a second. Richard is a fan, as I said, and we were texting leading up to this, and he says he needs to try Lalo tequila. I need to know, did you ever get your hands on Lalo?
I just had a tasting at a store, which I really
Uh-huh.
liked. And so I'm only going for tequilas that have no additives now that I'm hip to that. And there are some really good ones that I've had.
Well, I love that. So it's like people are learning not just about law in this podcast. So I get like Richard and you're not the first person to be like out at a restaurant to text me the menu saying, which of these? So I don't get legal questions, but I get tequila questions, which is great. But guess what? I have in my hands a fresh, beautiful, unopened bottle of Lalo that is coming to you, sir. So I'm
Oh,
gonna this is my thank you to you. And also, I always like to connect the story, right? To the tequila to the podcast that we're doing if I can. And I think I can do this here without much of a stretch. And I know I've told you this story offline, but Lalo is the grandson of Don Julio, and everybody knows Don Julio because Don Julio's everywhere. You see it in all the bars and all the Costco's and all the everywhere, right? And it's pretty expensive and gotta say, not that great. It used to be something special back in the day because it's one of the oldest, most prestigious tequila making families in all of Mexico. But as many great brands have done over the years, like Salsa is one of them, they sold out to a giant conglomerate. And once they did, it was mass produced and the quality went down, 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 down. And so now it's overpriced and under quality. And so we would never, unfortunately, recommend Don Julio. But why Lalo? Lalo, as I said, grandson of Don Julio. So when Don Julio sold out, they had a non-compete and they said, Don Julio, you can't make tequila anymore. And guess what? Your son, who works with you and is very knowledgeable, can't make tequila anymore. And the lawyers didn't account for the fact that there was a grandson named Lalo, and he wasn't part of the non-compete. And so he went into the tequila business and he makes just this. It's only a Blanco. It's amazingly priced. It's like $45. And it is, I think, for the money you spend, the best quality Blanco tequila on the market right now. And so I love Lalo. And what does that have to do with what we're talking about today? Well, maybe it's a stretch. But here's what I think. This whole case, Stormy Daniels, hush money, it all started where? In the Southern District of New York, the Sovereign District of New York Federal Court, which we will call the granddaddy of all uh, courts, of all prosecutorial offices, right? This SDNY, the famed SDNY. And so we're going to be calling Don Julio. Now, for some reason unexplained, and maybe you can shed some light on this, Richard, because I don't know, but you know, Trump was named in the indictment charging Michael Cohen in the Southern District of New York for essentially the exact same set of circumstances. He was individual number one who directed Michael Cohen to commit this crime. And Michael Cohen pled guilty to this crime. Michael Cohen was sentenced for this crime. Michael Cohen went to prison for this crime. And so the real question is, to me, that sounds like a dead bang slam dunk, if ever there was one, to prosecute the president. And there's a policy that says you can't do it while he's sitting president. The question is, why doesn't, once the SDNY flips into back in under the Biden administration, why don't they charge this? And for some reason, they have chosen to not do that. And now that it's kind of gone, I would say, downhill a little bit to the grandchild. Lalo, we're going to call Alvin Bragg is Lalo in this situation. And now Lalo has taken up the mantle to produce the quality indictment that we're going to speak about today. That's too much of a stretch, right?
Well, the New York County District Attorney's Office is not a stepchild of or even the grandson of the Southern District of New York U.S. Attorney's Office. They have a long history of prosecuting white collar cases in addition to Southern District, going back to at least the Robert Morgenthau years, which were many in number. And some of the best people who became white collar lawyers worked in the Frank Hogan era in that office. These are names that are familiar to New York lawyers because they ran that office very efficiently, maybe too efficiently, for many years. So there's always been a sort of a rivalry between Southern District and the New York County DA's office, sort of, for example, with respect to the organized crime cases, the Gotti cases, and so forth.
Hmm.
So they have their own robust office there. But getting to your point about why SDNY, we call it SDNY. Sometimes we call it Southern, if you're a New Yorker, as opposed to Eastern or Northern or Western. But in the Southern District, the rumor is that Mr. Cohn refused to describe all of the criminal activity with which he was involved, some of which may have implicated family members in tax crimes or other crimes. And in the Southern District of New York, like many U.S. attorneys' offices, if not all, it's an all or nothing thing, cooperation.
Mm.
You either tell them every darn thing you did
Yeah.
from the time you were a bouncing baby boy or girl until the time you enter the room with the U.S. attorney. So the rumor was that he had declined to give the full extent of his prior criminal history to the government and therefore was deemed somebody that not cooperate with the U.S. Attorney's Office. Um, and that may or not, he may have changed his tune post Trump administration, but we don't really have what we federal lawyers would call 3500 material and what is called, in New York law, Rosario material. Some of it could have been disclosed into the New York discovery law already to Trump's lawyers, but we don't know exactly what Mr. Cohn has disclosed to them. But that's
And
apparently the reason. However, there was lots of other evidence that they had against Trump that they could have used to indict him, aside from the testimony of Michael Cohen. And so they could have indicted him, and they, for whatever reasons, they decided not to, and they are not saying.
all right, so let me follow up on a few of these things. One is interesting about the rumor and the family members, and I do remember hearing a little something about that. That also, it's you've seen this, I'm sure, is a little common tactic, especially by federal prosecutors, which is, okay, we know there's other people that have done these things. We're going to give you a plea, and if you don't take it, we're coming after fill in the blank. We're coming after your kid. We're coming after your wife. We're coming after whoever. And so, because a lot of people are like, why did Michael Cohen, he's the only one in this whole orbit to plea. Everyone goes to trial in the Trump orbit, right? And he could have ingratiated himself and maybe whatever, gotten apart and blah, blah, blah. But he didn't do that. And I think one plausible explanation, speculation, of course, behind the scenes is he ate this to and went to prison to save some other people. Who knows? Possible.
Uh, I think that
Speculation.
he tried to save himself, and he testified before Congress where he fully implicated Mr. Trump
Yeah.
by name, and so he was hoping that I think that his testimony in that regard would get him considerable slack from the judge, but it actually didn't turn out that way.
And then I want to follow up what you said about 3500 material or what you call Rosario material in the state, just so, not everybody listening is familiar with that. So I think we would call that our Jenks Act stuff in the federal court, but usually what we're talking about is prior statements made by a witness at trial, right? Are we also talking about what we would call exculpatory information? too, or just
Or
are we just talking about
favorable,
statements?
favorable information.
Favorable information. Okay.
Right.
And the reason I ask is because the whole hearing today was over the disclosure of these documents that were in the possession of the SDNY, and not in the possession of the state prosecutor, Alvin Bragg. And apparently it's a lot of documents that have to do with Michael Cohen or whatever. And I'm guessing that is probably in the purview of Jenks or Rosario that we're talking about here, right?
I mean, I haven't looked at the material, but if they relate to prior statements of Mr. Cohen or uh, statements about Mr. Cohen by other people that could be used to impeach him, yes.
Yeah. Yeah. And so people, I think, to stick up for our defense community brothers and sisters there, like these are the bread and butter of a criminal defense. A case against a client is only as good as the witnesses, who are testifying against them. And if there's a treasure trove of documents because the SDNY did a very thorough criminal investigation and got statements from this person or that person, then of course the defense lawyers would want to get their hands on it. And of course they would want to review it with a fine-tooth comb. So for anybody that's saying, this is just a delay tactic and everything else, I'm not certain I agree with that. And I also do not understand what the delay would have been from the Southern District in getting these documents, or the delay with Bragg in having the but that seems to me to be an unforced error. It doesn't make any sense to me.
Well, it was the Trump organization or Trump's lawyers that subpoenaed or got a court order for a subpoena for these documents. They were not in the possession of the New York County District Attorney's Office, and they're not part of the same prosecutorial team. So under Kyles versus Whitley, which is a famous Supreme Court case, they're not part of the team, and so they're not required to get it. But Trump did get a subpoena for these documents. What the delay was in Southern District producing them is unfortunate, I'll say.
We always look for the bombshells, like the big surprise of the twist in the story, and we don't know what's in those whatever 17,000 pages. So things could get interesting between now and the 15th, but put a pin in that. Let's talk about the charges in the case. There are 34 of them. I don't think we need to go over them one by one because they're all pretty much similar, but I'm going to have you describe them. But what I will say is there are two documents filed in this case, if anybody is looking for them online. One is the actual indictment that sets forth charge by charge what he's indicted with. The other is called a statement of facts. And I'll get your take on the statement of facts. It's filed also by the same office that just sort of tells the story. And not all indictments come with a statement of facts, especially not in federal court. But I will say, I think they did a pretty good job of just telling a story in here. And I always like to point that out, practice tips and everything, like get to the point, singular narrative, let's go. And they start out with one simple sentence. The defendant, Donald J. Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election. Boom, period. End of story. That's their case. And then they go ahead and tell the story about laying out the facts. So, what are the actual charges behind that story, Richard?
Well, the indictment charges 34 counts of the same crime. That crime is falsifying business records in the first degree. So this means that you commit the crime of making a false entry in business records with the intent to defraud and the intent to commit another crime or aid or conceal the commission of another crime. So this is frequently charged in New York County in white collar kinds of cases. And each one of the counts relates to an entry or a payment that was made apparently to Michael Cohen on a variety of different dates. So the scheme is that money was paid by Michael Cohen or fronted by Michael Cohen to Stephanie Clifford, also known as Stormy. And then they made it to appear as though these were legal fees that were owed to him when they paid him back this money plus some other money for a total of $420,000 in a series of payments that uh, were something like $35,000 apiece. And then they entered them as though they were business expenses of the Trump organization and legal fees that were paid pursuant to a non-existent retainer agreement, rather than an unlawful election payment, and also to avoid the payment of income taxes, because they would be a business expense, and this is not a valid business expense to pay off a porn star. So it is both with the intent to aid in the commission of a tax crime and also an election law crime. So that's the nature of the charges, and there there are 17 different dates on which the 34 counts occurred. So it's, there's a lot to it, but it's basically one scheme
Yeah.
that took place over basically the entirety of 2017.
And you talk about the tax, so the Trump org evades tax liability because they're quote unquote legal fees. But what I didn't know until I reviewed these more closely is that the 420 it was only $130,000 payment made to Stormy Daniels, but they guess they doubled it and then added like a $60,000 bonus or something for Michael. But the reason they gave him all the extra money is because they knew he'd have to pay taxes
Right.
and that they wanted to give him enough money so that when he was done paying taxes, he got paid back. Which, what, hats off to Michael Cohen because he may be one of the only people that ever got paid back for work that, done for the Trump organization. So at least he's got that to show for it all.
Yeah, I think he would trade it back if he could.
You might be right. And now let me ask you, so my understanding, I'm not the New York law, never have been, likely never will be, but these would have been misdemeanor counts, but for the falsification of the records were this extra element that it was done to with the intent to commit another crime and aid and conceal the commission thereof, right? Isn't that what kind of jacks it up into felony land?
That's right. When his intent to defraud includes an element to commit another crime or
Yeah.
to aid and conceal the commission thereof is the actual language.
And I think some of the legal talking heads, who are mostly prosecutors, I don't know, or that I see on the news, but they think that somehow that's a stretch that to boost this from misdemeanor land into felony land by adding this element of in the commission of another crime. But it doesn't sound like that much of a leap to me, given the facts that we
It's
know to
not.
be true.
It
Yeah.
is not. I mean, these are mostly, they like to call themselves former federal prosecutors. But the people who have been former assistant district attorneys or, dare I say it, defense counsel in New York generally will say that it seems like they have a very strong case that he committed this crime, and it is unlikely that he's going to be able to prevail on the grounds of, I didn't have an intent to defraud, and I didn't have an intent to conceal my crime, and I wasn't trying to commit another crime. Those are all legitimate defenses
Yeah,
that he can advance by
he
saying
can
it's a
and
witch,
will.
whatever he wants to say.
Right. And by the way, the statement of fact says we don't have to guess about whether there was another crime involved because it's already been prosecuted and disposed of with Michael Cohen. The crime was a federal election fraud crime, right?
Well, yes, but they still have to prove beyond a reasonable doubt that it was done for that purpose.
Mm-hmm. Okay. So and I'm maybe putting you on the spot here because I didn't ask you to talk about this, but it occurs to me that we should talk about, well, I want to talk about what is the range of punishment for one count, one felony count, and we'll talk about the big picture too, but it also strikes me that maybe we ought to think about what would have been the punishment for it if he gets a lesser, because I guarantee you that they're going to ask for a little lesser included offense instruction to say, yeah, the falsified records, but if you can't prove the crime element, maybe a jury sometimes they get they split the baby, so to speak, and we get a lesser included offense, and maybe gets convicted of misdemeanors. So I
Well,
almost would wonder what that would look like too. I don't know if you're prepared to speak to that today. If not,
I
that's
am.
okay. Oh, of course you are. You're prepared for everything. So anywhere you want to start in that universe of potential punishment, please.
So, if he was convicted of only misdemeanors, it is likely that the sentence would be maxed out at 1 year. Um, I think there's a provision in the law that I saw this morning. I'm not 100% sure, but it looks like it would be a maximum of 1 year for misdemeanor. Um,
This is before we get to the discussion about concurrent versus consecutive, right?
right.
Okay,
And he
we'll put a
also
pin
could be
in that.
sentenced up to, he also could be sentenced for a misdemeanor split sentence, which I think for a misdemeanor would be 90 days in probation as a maximum, or 90 days and 3 years probation if it was a
90 days jail.
misdemeanor, 90 days jail, 3 years probation for a misdemeanor, versus if it was a felony, usually 6 months jail, the balance of 5 years on probation.
Okay.
But under the state law now, probationary sentences for felonies can be 3, 4, or 5 years.
Okay. And so that's the misdemeanor. What about the offenses as charged?
So if he were convicted of one Class E felony, which is falsifying business records in the first degree, the maximum term of imprisonment that he faces is 4 years. And then it's an indeterminate term of imprisonment. So an indeterminate term of imprisonment means that he does not necessarily serve that time. And then there can be, or there will be, a minimum sentence that you have to serve before you can get parole. And so under New York law, the minimum term, if you got a state prison sentence of 4 years, would be 1 year. And the largest minimum sentence that could be imposed for a 4 year term would be 1 1/3 years.
And is that like flat time day for day, or do they still have opportunity
Reduce,
for early release out even out in those 1 year sentence?
well, there is good time,
Yeah.
which is 6/7 or one seventh of your time. You have to do 6/7 of the time for good time. And your conditional release date is usually 2/3 of the sentence time. So whatever 2/3 of 4 years is. So I guess that would be 2 years, and the 2/3 years would be when you, what we call the conditional release date, or in New York we call it the CR date, and that's what the date you would have a parole hearing. But you could have a parole hearing much earlier. If you don't, if you do good time, you're going to get out at the conditional release date. Is usually how it works, unless you get out earlier.
Okay. And now we want to talk about this concept of consecutive versus concurrent sentencing. Most people probably understand what that is, but just the short answer is if you get convicted of more than one count, sometimes the judge has the option to run those back to back. In other words, if it were maximum 4 years, it'd be 4 plus 4 plus 4 plus 4 or 4. That's consecutive. Concurrent means they all sort of run together. So even if you had 13 counts with 4 years, it would just be 4 years total because you're serving all of those at once. So the question then becomes, since it's a 34 count indictment, does the judge have to go one way or the other? What are the options for the judge?
Well, the judge has authority to sentence to consecutive terms of imprisonment if the crime is not a single act or omission or a single criminal transaction. So it's fact-based determination that the judge can make. The judge is not required to impose consecutive sentences, even if he does find that there are separate acts or separate criminal transactions. But if he does make such a finding, then he would be permitted to impose consecutive sentences. There is, however, a statutory maximum, and the maximum minimum that he could impose under such circumstances.
Oh, do you know what that is?
I do.
Oh, of course you
I do because I looked it up.
do.
I
This
thought
is
I
the
could start.
mark. This is the mark of an excellent lawyer. Always prepared. No question can't be answered. And if he doesn't know the answer, he's going to fake it, and it's going to be so convincing we won't know the difference.
Yeah. So it is a maximum of 20 years. For
Okay.
those of you following at home in your book, it's 70.30, 1EI of the New York Penal Law, maximum of 20 years.
Okay.
And the maximum minimum is one half or 10 years. So the judge could not impose more than 10 to 20.
Okay. And we've done other podcasts on some of the other indictments, and I've done them with Mark Allenbaugh, which, he loves to do real deep dive into life expectancy. And either of those options, 10 or 20, is well beyond his life expectancy. But I guess we should talk reality. I know we could never begin to predict an outcome. And again, presumption of innocence attaches. He may not be guilty of anything and may never be guilty. But, there's two things we contend with in a case like this. I think the naysayers would first say, well, this charge is unheard of at all. So there's really not much we can compare it to. Because my ultimate question to you is, what can we expect? What's normal? What's a ballpark? What do people on average get? It's something Mark Allenbaugh would geek out on if he had all the New York statistics to look at every single person ever convicted of a case like this. But the fundamental question to start is this a case that we see, or is this just a special shit sandwich served up for the former president?
It is a case that we see, particularly in New York County in white collar cases. They do bring these kinds of charges. Now, what sentence will be imposed depends largely on how serious the judge views the crime or the offense conduct, and what the judge thinks of the defendant's prior criminal history, good and bad things about him. Some people think there are good things to say about him. I don't count myself among those people. In fact, I joked to his attorney, Susan Necklace, that I look forward to reading her sentencing memorandum. But in what she actually thought was funny, she has a good sense of humor. So it really depends on what Judge Mershon thinks is appropriate under the circumstances. I expect the New York County District Attorney to recommend a sentence of imprisonment, maybe even a consecutive sentence of imprisonment. I expect them to request that he be sent to state prison. And I think that it is very possible that the judge could impose such a sentence. It could be justified by the harm to the citizens of the United States in making their voting determination in 2016, which is a substantial harm, much greater harm to the public than the loss of some tax revenue from the Trump organization. And of course, it was intended to hide from the American people Mr. Trump's sordid involvement with Daniels and other women that he has sex with. So from that point of view, it could be seen as a very substantial damage to the citizens of New York and those, or as we like to say, the people of the state of New York, but also the people of the United States of America. So I think the judge could justify such a sentence, but we'll have to see what he wants to do.
You really raise an interesting question I didn't even think about. But when I talk most about federal cases, and I'm intimately familiar with the way the guidelines work, what might be offense conduct enhancements, what things a judge can consider under the guidelines, and if the judge can't consider them under the guidelines, can they then go over to 3553 and talk about the nature and circumstance of the offense and the history and characteristics. So you speak to all these things and you mention his past conduct, prior criminal history, but he doesn't really have prior criminal history per se. So my question is, in this playground, what can the judge consider? Can he look at pending criminal counts? Can he look at the New York fraud judgment? Can he look at past history of his charity, all the trouble he's had in civil arena? Like, what is anything fair game for the judge to
Yeah, it's
consider?
all fair game. The judge is unlikely to make a finding that he thinks that Mr. Trump has committed crimes for which he's not been convicted. However, the Trump organization was convicted of a crime in front of Judge Merchan himself, just I think last year. And Mr. Trump was intimately involved in the criminal activity there, as the judge well knows. And he's aware of, say, false testimony by Mr. Cohn at the behest of Mr. Trump in connection with this matter, which is the crime to which Cohen pleaded guilty. One of the problems with impeaching Mr. Cohen is because he did the crimes at the behest of Mr. Trump. That's why he committed them. So all of that is going to be relevant. And certainly the fraud finding was something the judge can consider. And the finding before Judge Kaplan that he committed a sex assault and lied about it, all of that is relevant determination of sentencing. And the continued threats to Judge Engeron
Mm-hmm.
in New York County State Supreme Court, I'm sure will not sit well with Judge Merchan. In fact, I expect more attacks on the judiciary during the course of the trial by Mr. Trump. And I think the judge might just take a dim view of that when it comes to sentencing. It doesn't seem to occur to Mr. Trump that attacking the judge who will impose a period of imprisonment on him is something that one may not be viewed positively by the judge.
Yeah.
So, and the
Well,
judge's prior attacks on the judiciary, his prior settlement for $25 million for a fraud, and that, the judge, his attacks on that judge is, he couldn't
yeah.
possibly be fair because he was, I think, a Latino person. All of these things will be
Well,
stuff that the judge can take into
and
account.
and I can add a pretty big one to that pile, which is I just watched a new documentary about Stormy Daniels. It's on Peacock, and it's very well done, but it's all about what she has been through as a result of her speaking her truth about what happened. And she's had her life turned upside down. She's had multiple death threats. Her, she has a child that's been exposed to all this stuff. Like she has been through hell, and it's going to start all over again the second she's got to stroll back into court and subject herself to that too. So brave person. I mean, great doc, left with a brand new respect for her, but she's not a listed victim in this indictment, but she has been victimized more than probably anyone in that whole litany. And I think that I don't know how the judge doesn't consider the hell that she's been put through over this. So could get interesting. Okay, so my question then, okay, so worst case scenario, if convicted, does he get to stay free until sentencing, or does he get taken into custody right then and there?
It's discretionary. So the
Okay.
trial judge has the authority to remand him right then and there. Um, he could, he may or may not do that. If he does, then Mr. Trump will have um, the right to seek bail from the appellate division of the state Supreme Court, which is our intermediate appellate court in New York, which, he will certainly do. And he could get bail there. And also, if he is sentenced, he could be remanded right there. In fact, I think it'd be likely. And then he would have to seek bail pending appeal from, after he files a notice of appeal, he would have to seek bail pending appeal from the appellate division. You could ask Judge Merchan, but you only get one shot at bail pending appeal after you are convicted, after you're sentenced.
Okay, so let me back up. So let's say he's convicted. You're saying it is discretionary. The judge could take him into custody before sentencing, right upon conviction. So I guess my question is, to the extent there's a normal, is that something, if it wasn't a former president, because I do think he's getting a lot of preferential treatment because of his special status, even if it's for logistical reasons around him security wise. But I guess if this were just an average Joe Schmo convicted of these counts, what would be the odds that they'd get taken into custody right then and there?
Oh, probably not.
Okay. All right. So I'd say that's almost definitely not. But you're saying if on the outside chance he does get taken into custody, probably doesn't happen, he can still appeal that. Now, does he have to wait in custody while that appeal happens, or does that stay his need to go into custody at that moment in time?
So if he was, suppose the jury comes back and we say, well, and so say you all, he's been convicted of 34 counts and the judge remands him. That means he's going in that day. His lawyers can go get bail, possibly that day, or, they have to give reasonable notice to the DA. So probably the next day they would make a motion for bail while pending sentence before the appellate division, and it may very well be granted. But
Okay.
presumably he'd be in for at least a day if that happened. And the same thing if he was convicted and then sentenced, even if he was kept out after a conviction, sentencing usually for somebody who's out would take place in about 60 days. If he was in, it would be about 30 days. When we say in, lawyers refer to somebody being in as somebody who's
In
detained
custody. Yeah.
uh, in custody. So at the sentencing, he could be remanded then and there, and then he could seek bail pending appeal, but he would have to be in unless the judge permitted a surrender date, which rarely happens, but could happen.
Okay. Interesting. Because we often get surrender dates in federal court, especially in white collar cases. But you're saying, and then you said that was going to be my next question, but you answered it. So typical delay, typical time between the end of a trial and conviction and sentencing is about 60 days. It's often longer in federal court, so that's a quick timeline, even quicker on the outside chance he's in custody. What are the chances? Because, delay is always a friend to this defendant, many defendants. What are the chances that he could get more than 60 days if he wanted it?
Uh, I mean, it's discretionary with the judge. I mean, the probation or pre-sentence reports that are conducted in state court are much more pro forma than those with which you may be familiar in federal court. There's a very short report. They do interview the defendant. Oftentimes, they conduct these interviews without counsel. You can request counsel, and it's an issue whether they'll permit counsel. They might permit it for Mr. Trump because he's Mr. Trump. I'm not sure what the current practice is in New York County, but there's an interview from him for him, which usually if a person is convicted after trial, they're not going to say anything. Of course, if it's him, he might wax eloquent to his disadvantage. Who knows? Uh, and then that report, very short report, several pages in length, will be produced, and parties can look at that report something like 48 hours before the sentencing. And they can provide a sentencing memorandum like we do in federal court, which is not done as often in state court, even after trial. You would be surprised to learn in state court, a lot of lawyers don't do them. And then the DA makes their recommendation, usually on the record in open court, where they ask for the maximum period of imprisonment, and then the judge decides, to what sentence to impose after hearing from the defense.
You said that they rarely file sentencing memos in state court?
Let me just amend that. There are, you know, if in some of the better public defender offices, if somebody is convicted after trial, they do prepare some kind of mitigation report that is submitted to the judge, usually written by the social worker and not the lawyer.
Mm-hmm.
Has been my experience, but I don't want to. I don't want to give the wrong impression that some of my colleagues might protest. So I'm sorry. So what was your
Okay.
next question?
The good ones file to do that stuff. And I know that the one of the defender offices there, I think it's a Bronx defender, I can't remember, but they do a lot of sentencing videos now these days. So
That's
There's
right.
definitely
Yeah.
some great mitigation being done in state court, but I don't know if that would be the situation here because how do you mitigate someone who's going to say I didn't do anything wrong and this is a witch hunt and you're all corrupt and you suck? It makes the defense lawyer's job a little tough. You're giggling, but it's true, right? Like, what are you gonna say?
They can show him, he loves his daughter. They can show that.
Oh, I'm not touching that one with a 10-foot pole. Um, wow. Yeah, now I'm speechless. Let me get back. Let's get this bag on track. So, okay, but tell me, like, where, we've all heard of the famed Rikers Island, a hellhole of epic proportions. Very, very difficult to imagine anyone going in there, let alone a former president of the United States. Can he avoid that? Can he go directly to the whatever facility? You said there's a possibility he could self-surrender, right? So,
It is. It's possible.
yeah.
However, I understand that some high-profile people have been allowed to occupy a separate floor or something like that in the interest of security, or because the person is high profile, they might clear out a building or a wing or a floor or something for the former guy so that he could camp out there with, Secret Service agents or whatever.
Well, that will be interesting. I don't think anybody knows. I don't think anybody's wrapped their head around the possibility that he'll ever end up in a custodial setting, and more specifically, what that would ever look like from a logistical point of view. That's too much. I guess we'll take it one step at a time. I think I only have one more question for you, and maybe a little out of left field. But what are the chances this trial is televised and the sentencing is televised? Because they can do that in New York, right? Not federally, but
I think it is unlikely. There's been a lot of controversy, and I know the criminal defense lawyers associations have always been against this because of the grandstanding and unfortunate snippets that are going to be taken out by the local news in your more typical case. So, in your more typical case, it's going to be broadcast. There'll be a sensational crime that'll take place in a particular community, whether it's New York City or say it's on Long Island or, you know, upstate in Rochester or some city where it's going to take over the imagination of the city. And then at the 10 o'clock news, there'll be 30 seconds broadcasts of something from the trial, which is really unfair representation of the trial. Now, in the case of the people of the state of New York against Donald J. Trump, I think it would be in the national interest for people to hear and see the witnesses. But I think it is unlikely that the judge will permit it.
I kind of feel like if this is the first one to go and he could end up in prison over this, we'd want to be able to see and hear for ourselves what's happening rather than rely on the pundits to give us the play-by-play. I would hope this thing would be, but who knows? What did I forget? I want to give you the last word. Was there anything really interesting you were ready to talk about that I didn't ask you?
Well, I have learned that there's a thing called protective custody for a sentenced prisoner who is like a former law enforcement official or a cooperator, and that they put these people in a separate wing of the facility together, that they don't have any contact with people in general population. And so your ordinary protective custody person, they have a plan for what to do with those people. So he could go into one of these protective custody wings. However, the scuttlebutt is that they would take a closed correctional facility, of which we have some, and reopen it for the purpose of imprisoning the former guy, because it would
Interesting.
be easier for the Secret Service to go there and watch him there and to keep him away from near do wells. So that is a possibility. If that is true, then he would not face the same level of justice as some of our other clients. And, we could view that as unfair, that he's getting preferential treatment. And I should add that I don't think that the federal law for the Secret Service requires former president to be protected. It permits a former president to be protected. I think that's my reading of the law. So whether the Secret Service would actually have to go there and supervise him on a moment-to-moment basis is in doubt. They might, have somebody check, but I don't know that they would really need to have a full presence like they do now. He certainly doesn't deserve it from my point of view, but I don't know. This is also a matter for the executive. That is the maybe the Attorney General of the United States to make a decision about.
Yeah. Well, yeah, it'd be interesting if he's never going to be in general population, but one would argue he's in pretty good with the tiki torch carrying set. He might have a lot of protection if he ended up he might have a lot of friends in there. Who knows? But then again, maybe not. Here's my theory. If I'm king of the world, I would tell Letitia James, because she's
Oh,
trying to collect, all the money for the civil thing, to figure out how to forfeit either Mar-a-Lago or Trump Tower, and just turn that into a little private jail. It's fine. It'll be home confinement. It'll be nice and cushy, but he could do his time there. It'll be fine. And then when he's done with his sentence and done with his life, I'm not suggesting his life should be over prematurely, but I'm saying eventually he will no longer be on this earth, and we turn that place into a museum of democracy and let everybody come and see. That'll be fine. I think Mar-a-Lago would be better. It'd be more spacious for that museum. All you got to do is say you can't go to the omelet bar, you can't play golf, and no visits from porn stars for you, and let him just serve his time there. I think that would be fine. I'd be okay with that.
well, there's also criminal financial penalties, which is interesting.
Oh, in this case?
Well, there is a possible fine, which can be up to double the gain from the offense. So I wonder what the gain from the offense is.
Oh, that's so interesting. How do you even quantify that?
That's an interesting one. Suppose it's his 4 years of salary and double it. I don't know. I mean, that could be one thing.
Yeah.
What about the emoluments that he got while he was president of the United States?
Allegedly.
Uh,
I mean,
Well,
if to hear Trump tell it, he lost billions by being this gracious public servant. So, I don't know how you'd ever put a dollar figure on all that.
yeah. So I mean, otherwise the maximum fine is $5,000. And then I guess there's, you know, the question of whether anybody is owed restitution for this offense. That's another question. Maybe not, but these are for him. He loves money, so any time he's required to pay money would be a negative for him.
Yeah, absolutely. Well, Richard Willstatter, you don't have a Nobel Prize to your name, but I argue you should after today's performance on set for sentencing. No, honestly, I think we've had a discussion that I have heretofore not heard any of the details of the possible ramifications of this yet. So I'm very grateful to you. Thank you for doing your homework and for being prepared for every question. If anybody, first of all, I hope that nobody ever would need your services and your help. But if perchance you're in New York and find yourself crosswise with the law in state or federal court, go to greenandwillstatter.com, and I will put that link in the show notes along with your bio. I'm going to put the indictment in there, the statement of facts in there, a couple of links to some other episodes that we've done that might be relevant to this issue, and stay tuned. We're going to have to see what happens, but I so appreciate you, and hopefully we can do it again. And keep on the lookout for your lovely bottle of Lalo, my friend.
Thank you. I just want to give a shout out to my friend Alan Rosenthal, who used to be at the Center for Community of Alternatives, for giving me some background on where people get placed after sentencing. in New York State.
Yes, thank you. Thank
to him.
you so much.
Thank you to you, Dan.
Absolutely.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassenlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.